Tonight we're speaking on fashion law and the fashion industry. Everyone who's here either is an attorney or a business professional, an entrepreneur, possibly a law student, and so, or somebody who's interested in learning more about the industry. It is, if you guys read the promo, it's a massive industry. It's a $1 trillion global industry, and it's continuing to grow year after year. We have a wonderful panel of distinguished industry professionals with us tonight, from the trade association leadership perspective, from a successful entrepreneur, to the private practice perspective, and the in-house perspective. So without further ado, I want to pass it over to the panelists to quickly introduce themselves and provide a background of their companies and their experience with the industries.
Okay, from here. Good evening. Thank you for allowing a non-professional to be here. I'm here for comic relief. I represent business and how the laws affect business. The California Fashion Association began 18 years ago on the issue of labor law, but we have morphed into all issues, particularly IP, international IP, all of the issues that affect the business of the business. And I started it 18 years ago, and we don't want to go into ancient history, but believe me, I've been in every facet of this industry, so I'm delighted to be with you, and I look forward to meeting all of you if we have something to talk about. And then a little commercial. We hope that you will consider being part of the California Fashion Association. You need to know what the issues are that affect your clients, not just IP, but all of the issues that are in the newspaper right now affect your clients one way or another. And that's what we do. Thank you. Jay.
Good evening, everyone. Thanks for having me. I am also a non-attorney. So I appreciate you guys letting me say a few words about who I am and what I've done. I'm an entrepreneur and also co-founder of Primitive Shoes Incorporated. I started my first finance-related business in 2003, and a few years later sold it to one of the largest privately held companies in the U.S. And since then, I've done a variety of things, from consulting. In 2008, we started Primitive Shoes, Inc. We are a retail store, an online store, and have developed also into a wholesale clothing brand. We're currently being sold in about 800 different stores in the U.S., and we also have distribution worldwide. Thank you.
Hi, I'm Susie Yu. I spent the first 6 or 7 years of my practice working at law firms, focusing on protecting and enforcing the intellectual property of a diverse range of clients. I'm currently in-house, focusing on the enforcement and also of IP and also corporate transactions. So I have a huge passion for the fashion industry and hope to expand my practice to include more of this area.
Good evening, I'm Patty Connor. I'm legal director with Volcom. We're a mid-sized surf skate snow company. And about 2 years ago, we were acquired. I always say we were acquired by the French. French conglomerate who specializes in luxury brands, mostly Gucci, Yves Saint Laurent, Bottega Veneta, Stella McCartney, Alexander McQueen. And they wanted to diversify, so they started to acquire several sports and lifestyle brands, starting with Puma, Cobra Golf, and then Volcom. So I work in this pretty small, little, eclectic board sport company.
Enough to get to follow my passion into an in-house job in the fashion industry. So for everybody out there who, and I think I've spoken to some of you who that's what you're looking to do, it's possible. You don't necessarily have to have a huge background in fashion. Just a love of clothes. Really, that's really all I had at the time. For those of you who don't know, and I'm hoping that's mostly just the men in the room and that the women do know, BCBG is a high fashion women's apparel company, and we own several brands, BCBG, BCBG Generation, Hervé Leger, which is sort of our high-end couture line, and a couple other smaller brands as well.
Thank you very much. Before we get into the legal nitty-gritty of fashion law, we're going to have Ilsa provide an industry overview. Ilsa is a real leader and advocate for the industry, and so I think she's going to be able to provide a really insightful perspective on the industry as far as the different business models, the major players, the trends. So, Ilsa, if you could.
My pleasure. Thank you. So, one of the issues that came up in recent years was the plan to make design copyrightable. Up to this point, knockoffs are legal, and hopefully they will be legal forever, because there is really nothing new in the world of style. The question is, what is originality? Now, please understand that the way the bill has been written, in many, many ways, no one has to copyright. All you have to do is decide that you did it first. And in saying that you did it first, you're coming out of the Rhode Island School of Design and you did it first, and there it is on the runway in New York, and you send a cease and desist letter. Game on. That's the way the law is written. So the question is originality. We at the CFA really took a very strong position on this. We pounded the table in Washington and in Sacramento and locally. And what you have here, Narcisco Rodriguez took this dress on your left to Washington, pulled it out, the original dress on the deceased Mrs. Kennedy, and said there were 8,000 copies. I should have had a piece of the action. I should have had a royalty. Of course, in 1960, it was a Vogue pattern, and Mr. Rodriguez had been an assistant to Bill Blass in 1973, and there it was in 1973. Kate Middleton was married on Friday, April 29th. By Thursday, May 5th, the dress was in the UK Mirror, and by May 6th, it was on the cover of Women's Wear Daily. However, so that's knockoff. Here we have Isabella Orsini, a Belgian lady who wore the dress in 2009, and better yet, the exact replica from 1991. Originality? Who exactly was Mr. McQueen going to sue? So we have the same thing. What is substantially identical? Those are the phrases on the bill. Okay, Catherine Malandrino, Zara did it at $39. I wore this dress when I was pregnant 50 years ago. Prada, satin rope, Old Navy at $24.50. This is the name of the game. This is apparel. That person who is buying the wedge at $24.50 doesn't even know who Prada is. Here we have another issue that is primarily a problem with the bill. Karl Lagerfeld, $2,200, Zara, $129. So you have Sweden knocking France off. But the bill only addresses U.S. manufacturing brands. So these people are off the hook. In Europe, and everybody says the Europeans have this, and they don't. Europe has what is called RCD, Registered Costume Design. You must register in Europe. And guess what? Loser pays. That will never happen in the United States. Then we have the other proponent of this bill, Madame Furstenberg, who waved her wrap dress in front of Congress. And she did it in 1975. She's still doing it. This is 2009. It's time to retire the dress, okay? But there it is, again, as a Vogue pattern of the 60s. But in 1942, Claire McCardle, who is in the Metropolitan Museum now, she had a popover dress, and she did it for 40 years. In utility, achieved with ingenuity, McCardle found a synergy. This was a utility item. And up to this point, fashion has been called utility. Is fashion art or is fashion business? And we say it's business. The law includes jeans, it includes eyeglasses, it includes umbrellas, it includes gloves. Until they make a 6-finger glove and a 3-armhole dress, nothing is original. And I must tell you, my office, my crack staff will find anything. Then you have this issue. This would be illegal. This whole issue that we all see when we're getting a manicure in every magazine will be gone. Can you spot the knockoff? Isn't that what life is all about in the world of fashion? And believe me now, fashion changes every 10 weeks. So my suggestion to all the people who sue is make another one. Just keep going. Just keep going. So this is primarily the issue that we've dealt with for the past 3 years. Another one coming up that I will just briefly tell you is designer parodies test legal boundaries in streetwear. The whole issue of parody now on the internet is going to be on your desks soon. Does it hurt Hermes if somebody says homies? The whole issue of parody is going to be the next thing that the egocentric designer who thinks that their brand is setting the world on fire is going to be in front of you with. And so I look forward to having conversations with my colleagues on the panel, because sometimes I think we're going to sit on the other side of the fence on this.
Thank you, Osa. That was very interesting. Jay, you founded and ran a lifestyle skate apparel brand, which is now doing business globally. Can you tell us a little bit about your business model, a little bit about the business model and trends of your particular sub-industry, and your thoughts for the future of it?
Sure. First of all, what Elsa was saying was so true as far as the parodies go, and especially the market that I'm in, the streetwear and skateboarding. When you have a brand that mocks, the French brand Comme des Garçons by saying "calm the F down" and putting it on a shirt, and it's one of the biggest selling items in streetwear right now. That it's fascinating, and it's something that is going to be more of an issue as we go along. But getting back to me, we started Primitive in early 2008, and during the beginning of the financial crisis, and people said, "You guys were crazy. It's not going to work. There's no money in selling shoes and streetwear and skateboarding products." But what I knew was that there was a gap in the consumer market that could be filled by using the internet and social media as means of advertising and getting the word out. And we've been very successful in doing that. Now, what we've done is not unique in any ways. Many of the emerging brands these days have used the same model and have become quite successful in doing so. Culture is becoming continually fragmented and will only continue to do so. As little as 30 years ago, everyone was watching the same 7 television stations, were listening to the same 4 radio stations, and everyone was watching the same blockbuster movies. They got their news from the same newspapers and other, media outlets. Eventually, cable TV started to take market share from broadcast TV, and it's kind of snowballed ever since there in every market that we deal with. iTunes and the MP3 has completely changed the music industry, as you know. YouTube has completely changed the way movie and television industries, focus on how they develop products. And as adults, this is something that we understand as a huge shift in the way media is delivered. But you have to understand, for young people, this is just the way things are. That's all they know. They're growing up in a world that's not dominated by big box mainstream media. Young people don't distinguish between mainstream and underground niches the same way we do, and they never will. It's just the way things are. And to a large extent, the same thing is happening in the fashion industry and has been happening during the last decade. We've seen smaller brands continue to take market share away from the larger ones. And this is because of the internet. And it's also because of the fact that the barriers to entry are not as large as they used to be. It's becoming increasingly easier for people to make their own t-shirts and accessories. Things like 3D printers are allowing people to create their own molds and templates for products. And most importantly is that big box retailers are no longer scared to take these new brands in with open arms, and in a lot of cases they're finding that they're performing exceptionally well for them. Fashion trade shows, for instance, are becoming less of a centered, spectacular event, and they're becoming more of a series of shows that can better represent a specific niche within the industry. If you guys go to Magic, you'll see that. And Magic used to be this one huge event where everyone, gathered into the same place. Now there's specific shows with different names all over Las Vegas for streetwear specific, skateboarding specific, anything you want to do. And that's just kind of the way that the market is evolving. So it's very important for these brands, as well as the large brands, to protect their IP. And there's going to be a lot of interesting, issues that are going to come along in the next few years with regards to this. Now, that being said, I strongly believe that there are certain big brands that will always win. And that's because there are certain barriers, mainly in technology and performance, that only companies with historical aggregated volume have the money and resources to invest in these type of things. Several of the panel members here tonight represent these type of brands. Thank you.
Thanks, Jay. Getting into the legal side of things, Susie, can you give an introduction and background on this growing area of law? And specifically, can you tell the audience, how does one define fashion law, and why would a client need an attorney that's familiar with fashion law?
Sure. So to start with, let's talk about what is fashion law. Fashion law is the area of law that deals with the day-to-day business issues that are unique to the fashion industry. So similar to entertainment law, with which there's lots of crossover, fashion law has intellectual property at its core, but also includes other legal disciplines such as commercial sales, corporate finance, customs, real estate, and in the case of counterfeiting issues, which we'll address later, also includes criminal consequences that fashion companies need to be aware of. What's also expansive about this area is the type of stakeholders who are involved that you wouldn't normally think about at first blush. So these include not just the fashion and apparel companies, but also producers of raw materials or textile companies, manufacturing facilities. And now with the advent of the internet to the fashion companies, we also have e-commerce players who are also part of this equation. And that also includes fashion bloggers, for example, who are a recent phenomenon, who have dramatically changed the way fashion companies market and promote their brands. Not only are the boundaries of fashion law expansive, but also constantly evolving. There's also crossover into many areas of law, in other areas of law, especially including entertainment law, as Jay discussed. We now have companies and artists who are multifaceted and who are more brand focused rather than product focused. So we have artists, so we have musicians and actors, for example, who launch their own fashion lines. So in sum, I think the most accurate and pragmatic way of defining the area of fashion law is to say that it deals with the business of executing and protecting any design-intensive products, and that includes clothing, accessories, shoes, and jewelry, and even consumer electronics. The second part of Sherrock's question is why there's a need for attorneys who have a deep understanding of the fashion industry. Well, to start, we have to understand the importance of fashion in the global, in terms of the global economy. The fashion and apparel sector has become one of the largest and most dynamic consumer categories that accounts for almost 4% of total global GDP, a sum that will reach almost $2 trillion in 2013, and which constitutes a growth of over 6% from the last year. So it's an industry that it's also an industry that employs more than 75 million people. So fashion companies have grown enormously in social and economic impact. This growth has meant that there is a lot at stake in disputes that arise in the fashion industry. So a few words in a fashion contract, for example, can mean the gain or loss of tens or even hundreds of millions of dollars, or even the control of a company. So lawyers and judges and juries need to understand what fashion is and how the industry operates, and that education starts with the attorneys.
Thank you, Susie.
That's a lot in 3 minutes.
Oh, yeah, yeah, 3 minutes. So as much as you can squeeze in.
We'll just try to distinguish trademarks by saying what they protect. This is a little more concrete than a copyright. A copyright is like the whole play or the whole script or the whole movie. A trademark is a word, a device, a symbol, a name, a slogan, got milk, something that is very simple. And you protect it by, I recommend filing digitally for $325 per class, which trademarks are broken up into classifications. They're goods and services, and there's about 45 classes. Most of them are goods. And so like my apparel is in international class 25, and then my backpacks, purses, wallets, belts are in class 18 under what used to be leather goods. And shampoos are in class 3 and services are in 35. So you have to file your mark in every class, in every country where you want to protect it. It's freaking expensive. Sorry, I work at Surfskate, no place. So generally, and I think we're going to get into it a little more, you need to strategically plan out, and I wanted to talk to Jay about this. How do you decide where to file? You cannot file every single one of your marks in every single class, which would be ideal so that you could stop all the counterfeiters, but you just don't have the funds to do that. So you want to file where your manufacturers are or where most of your retail accounts are. I think we're going to get into that on another slide. Recent cases and commercial impact. I'm going to have Susie talk on this slide. Are you going to do this slide?
No, that's you.
Oh, that's me. Okay, I didn't write it, but I'm going to talk about it. Select okay, here's what we're going to do. We're going to select a unique trademark name and phrase. So Jay started this new company called Primitive. He had to go out there, and it's a very simple word like apple, but he needed to make sure that people weren't using it in this manner. Did you do that?
Well, it's actually a complicated question because we've been sued by...
You didn't get an excellent lawyer to begin with.
We actually have several excellent... Sure, because...
I'm just there now.
Can anyone tell we didn't practice?
For the record, I was not his
To
lawyer
bring
yet.
up, we were actually sued by a furniture store in Chicago.
All right, so
So-
they had no standing, but they had the right to bring it.
Yes,
They
it's
didn't understand the classifications and the
the
distinction.
classifications, absolutely.
Exactly.
So, it's settled, we ended up settling, but just for the record, we are called Primitive Shoes and Apparel, not Primitive. So,
Excuse me, which is so marvelous, that will.
You know, actually, that's a really good point that you bring up and that's very, very important. We, on the law firm side, you constantly advise your clients when they're starting a brand, the most important thing that you want to do, whether it's fashion or any type of business, is what's the name of your company and what class of goods and services are you looking to provide these services and provide these goods for? And then you want to make sure that you do the adequate due diligence to see that not just with checking the trademark database, but many other sources to make sure that there's not going to be a conflict that might arise later. And unfortunately, what happened was when Jay and his partners were starting out, and this happens a lot with new business owners and entrepreneurs, is that they have a limited amount of of resources that they can allocate to all the different things. And their attorney at the time said, okay, you want to register this, it's going to cost you this much for a very comprehensive trademark due diligence search. And they're like, well, we can't afford that, so can we do something less? And so they did something less, and then a year later, when they're building their brand and growing, and the momentum is just unstoppable, they can't just switch their name. They get this notice of opposition for their trademark application, and they had to defend it. And so that's kind of the background.
Yes, the second bullet point here is conduct a thorough trademark search, and there's a lot of levels you can do that at, and you shouldn't do it yourself. You need to have someone who knows what they're doing and what the implications are, because if they had seen the primitive furniture, I would not have seen that as a bar in any way, shape, or form.
And we knew they existed.
Yeah.
But there was no likelihood of confusion in
Right,
my mind.
right.
So,
But it doesn't stop
you
them
know.
from coming after you and
Right.
hassling you and all that. And so you have to choose a mark, and then, I don't know if we've said it, but you need to use it consistently. You can't use it primitive shoes and then primitive apparel and then primitive clothing. You need to use it consistently. And so as an excellent example, I'm at Volcom. It's like a made-up term, like Polaroid or Kodak. It's a made-up term. No one else has it. And in the whole world, I've been watching this portfolio since 2001. There's 2 other Volcoms on the planet. One of them is a volunteer community, VOLCOM, in the UK, and we peaceably coexist. And, but I watch them. And then there's another one who is, oh man, what are they? It's like insurance or something, and I think they did it just to annoy me. But my mark is very easy to protect because we are the only ones using it. So then, to make my life lovely, we acquired Electric Visual Evolution. And they like to use the term electric for sunglasses and watches. And it's one of the more diluted, common, it's probably like primitive, if not 80 times worse. So I have the most perfect mark and the worst mark. But, so place your trademark symbol on your products. There's lots of different ways of marking your goods. You're putting the public on notice that you're using the mark in a trademark or service mark sense. The TM is for trademarks. You can use trademarks for all 45 class goods and services, or you can use an SM on the service marks if you are doing a nanny or a counseling or mentoring. You'd want to use an SM symbol, or on a slogan phrase, even if you use it in advertising, but for a physical good.
I have a quick point on that. So as soon as you place your mark on your product and it's placed into the market, you have what's called common law trademark protection. And that starts right away, but that's only valid in the geographical areas in which you sell your products. You want to register,
Good point.
after that, you want to register with the trademark office your trademark, because that means you have protection throughout the entire United States. Also, that also means when you file a lawsuit, for example, on trademark infringement, you're entitled to a presumption that you have a valid trademark
For the whole
if
nation.
you have registered that trademark.
Right. You know, when I started, we would file in the States. We would file in California, and we would file in New York. That was back in the day when you would prove use by, a Yellow Pages phone book or something. I mean, it was so different when the internet came. Oh, I guess some of you were born since that time. But it really has changed. And so file a trademark application as soon as you can. In the old days, we would counsel, if you've only used it in California, you can only get a state registration. You're supposed to have interstate commerce in order to get that federal level. But if you just, sell something to your sister in Utah, you can file on the federal level at semi-peace of mind. Anyway, I didn't say that.
Guys, I think at this point, we got 15 minutes left. We have so much more to talk
Okay.
about.
Oh.
Should we go into the Louis Vuitton case?
Great.
I'll just touch upon that very quickly. So this case, I wanted to emphasize just one point, which is It's always important to counsel your clients and to keep in mind that the underlying policy that drives trademark law is to protect consumers from the potential of confusion over the source of the product. It's not there to protect designers or creativity, which is something that Louis Vuitton found out when it sued Dooney and Burke over their multicolor trademark pattern. The judge ended up throwing out the case saying that, well, it's similar. The timing was similar because Dooney and Burke released their bag 3 months after Louis Vuitton did. And certainly during discovery, Dooney and Burke did not contest the fact that they were inspired by Louis Vuitton's bags. But it turned out, if you look at it carefully, there's no real way a consumer would be confused about buying a Dooney and Burke bag over a Louis Vuitton bag. The LV symbol and the DB symbols are a dead giveaway. Plus the price points are dramatically different. So at the end of the day, it's disconcerting to fashion companies sometimes when you have other fashion companies who follow your trend, but that's what fashion is about, and trademark law will not protect fashion companies that imitate your style.
Thank you, Susie. Patty, could you give a quick summary of the YSL case, and then we can go into trade dress?
Right. Louboutin brought the case originally in the U.S. District Court of Southern District of New York, and they were denied their motion for preliminary injunction against the Yves Saint Laurent for alleged trademark infringement because the court felt that they were unlikely to be able to enforce it. The district court level, the initial complaint, held that a single color can never serve as a trademark in the fashion industry. So this was pretty scary. So Louboutin appealed this, and they had 3 amicus briefs submitted. The major one, I would say, would be by Tiffany, because they have the color blue. And so the U.S. Court of Appeals, Second Circuit, came back, affirmed in part, reversed in part, and remanded. The appellate court ruled that Louboutin's trademark, consisting of this red lacquered outsole on a high fashion women's shoe, had indeed acquired secondary meaning as a distinctive style identifying the Louboutin brand. But they also concluded that Yves Saint Laurent could use their monochromatic red sole because it was the contrast that made Louboutins distinct. And so a monochromatic shoe did not compete with the popping black versus red. So it was, the way I look at it, since I'm on YSL's side, is it's a win-win. We now can keep, because of the Qualitex case, which was that pink insulation, it would have reversed so many trademark laws that the appellate court said, no, you can have a color, but it has to be very distinct. And so they narrowed Louboutin's red sole to just with contrast. So they modified it.
And it's just that color red.
Yeah, they had to modify it, but they did get to keep it. But YSL got to use their shoes as well.
I'd like to quickly transition to Erica. Erica, thank you very much for sitting there patiently. I'm very interested to hear what you have to say, so please take it away.
Okay, so wanted to touch on, thank you, I'm usually pretty loud, so I'm going to step back a little bit. Wanted to touch on trade dress a little bit, which, as we discussed already, there's no copyright design protection. So what do you do when you have something that is iconic to your brand, can't copyright it, there's not necessarily a mark on it, is there a way to protect it? And we've talked about a lot on the panel already that fashion is always changing, but there are, I think, a few areas where at least my company feels that we've really become iconic in a particular area. And that's particularly with our Hervé Leger brand, which is bandage dresses. And we have filed a recent case that has resolved against Stretta, trying to protect our trade dress in that particular bandage design. So I wanted to talk a little bit about sort of my takeaways from that experience and what I've learned in terms of best practices for a trade dress case. It's an uphill battle, I think we all know that. So the first thing I would say is definitely go out and get an expert report very early on your secondary meaning issue. If you have not acquired that kind of recognition, obviously this is going nowhere. So you really want to expend your money there up front to make sure that this is a battle that you want to fight. You want to pick those battles early on. So we focused our efforts on Strata for a couple of reasons. We had evidence of actual confusion, which for the lawyers in the room, you know that doesn't ever happen. So we actually had several stylists who returned Strata dresses to our marketing department thinking they were ours. They didn't look at the tag on the inside, they just saw the dress, it was a bandage dress, they sent it back to us. So that was a great fact for us. We also, the entire Strata website was bandage dresses. That was their entire focus of their company. This was not a one-off style that they had decided to put one dress out there. It was their entire business model. Not only were they just bandage dresses, but I'm going to be generous and say 99.9% of them were exact copies of designs we had already done. Some that were current, some that were in the past, things of that nature. So when you put them next to each other, there really was no question that these dresses looked the same. They also sold at a price point that, while lower than Hervé Leger, was high enough to create some kind of competition within the market, and they also sold in stores where Hervé Leger sold. So we felt like we had a pretty strong case with them in order to be our first sort of battle on this issue. We had all these good facts, and so we wanted to go down that path. And I think that's really important. Because it's such an uphill battle, the first one, pick the right one. You don't want to overreach on what you're trying to protect. I am in-house, so my client is our designers and everybody else at the company. And obviously, I get emails every day. This person is knocking off this Hervé Leger skirt, for example. Well, our bread and butter for Hervé Leger is not really skirts. So is that the battle I want to pick? Is that the definition I want to go down? So we had to really work very hard to define our trade dress in the complaint to be very specific to what we felt was actually protectable and not overreach, because I think that that's going to be a fatal flaw if you end up in front of a jury. And then sort of the last best practice that I learned from this is the value of consent judgments. So we did not end up taking this case to trial. We resolved the case, and part of that resolution was to file a consent judgment with the court. It's a win for us because we've stopped the ultimate infringement. That was our big problem. We didn't get a ruling on the trade dress issue, but we've resolved the immediate problem of a company that had an entire business model of copying what we believe is our protectable trade dress. And, it's out there, it's in the public, it's something we can use in the future to fight this case. Saved us a lot of money in outside counsel fees to just go down that path and get sort of what we needed out of it. So those are sort of my takeaways on how to do a trade dress case. Again, it's an uphill battle, but I think that it's an area that we're going to see more of within the fashion industry because it's sort of all that's left to designers right now.
Thank you, Erica. We still want to cover counterfeiting, and we want to cover licensing. So we're going to see how fast we can cover those two very big issues in the next 5-10 minutes, and then also maybe have enough time for questions. Moving on to the counterfeiting, Patty, do you want to, before I do that, Patton is all lead off.
On best practices, we've touched on a lot of it. You want to start with that strategic worldwide trademark portfolio. You can't enforce your rights if you haven't registered around the world. And so you go and you determine whether you're going to file for the word mark, primitive shoes and apparel, or a design mark. When Volcom was very young, we would file for the stone logo and the word Volcom underneath as what's called a combined mark. And thinking that to some degree we'd be getting two in one. Sometimes it works, sometimes it doesn't. It depends on the jurisdiction, and it depends how the knockoff artist or the pirate is using it. Register with customs. You can register with customs for the U.S. online, super easy. It's not very expensive, $80 or $100 per mark. It lasts till your registration, your federal registration needs to be renewed. And then you work with foreign associates to register in Korea or China. And then your goods will be stopped at the border. Very easily in many jurisdictions, they pay for it, except that CTMs, the community trademark, you have to pay for the destruction, which can add up to a little bit, but it's still been worth it. Security tags, you need to mark your goods, especially for apparel, so that when they're pulled by Dutch customs and they say, how can I tell whether it's real or not? I can say, you turn over and you pull the thread at the end. I won't tell you what we do, but make it easy. Get your employees involved. When they're on social media or eBay, if they see something that's questionable, have them. You can click on a fakes icon on our website and marches you through, and the email comes straight to my inbox. Online takedowns. We have people who do eBay and Taobao, Chinese language, and Pai and all of them every single day. You've got to keep up with it. Let the counterfeiters know that you're taking action, or your mark will become diluted out there. And I'm not going to talk about China. That's too long.
Jay, Ilsa, do you guys have some comments from your perspective on counterfeiting?
The counterfeiting business is 7% of all apparel is counterfeit, but that's huge if you're talking about trillions of dollars. But what is very interesting in the latest Gallup poll, 25% of the people who buy counterfeits know they're counterfeit and they buy them anyway. So what you have is perception of the buyer. And the more people want these brands, what is happening in our latest Gallup polls that we're coming out with in a new survey is that the youth, your customer, doesn't care about labels. And they really want authentic. That's the new phrase, authentic. And the aspirational labels are going to suffer for all of this. But U.S. Customs is very proactive, and they have gone from finding 6% of counterfeits to 15%. So the fact of the matter is, it's still all coming in. Watches, pants, and True Religion's latest bust that you will see on there came in as brooms.
Just a few quick things. I think the issue of counterfeiting is only going to continue to grow. We see with 3D printing and all these types of new technology available to people, how long until kids start putting your logo on their own tees that they make? It's not far away, and it's going to start happening. My advice to attorneys is make sure your clients control their supply chain distribution, because I think most counterfeiting is somewhat internal. You have factories making extra labels. What are they doing with their labels? Where are they sending to? Make sure you register your trademarks in the countries where your products are being made. It's well known, Nike, who is a huge counterfeiting problem. Most of those shoes are made by Nike people that after the factory, they go into a different job and they make the shoes over there. It's just, so it is internal, and it's something you really have to watch. We've experienced it already in several different countries. So that's all I have to say.
I just, before I go to licensing, which I think is
please.
next, I was just going to add on for the best practices in terms of anti-counterfeiting. I think educate your consumer should be on there as well. And particularly for aspirational brands, we see very often we will get emails from customers. I got this dress. Is it real? Can you confirm? I don't think it's real. I just got it and I need to go dispute it with my credit card company or whatever. And what we do at this point is we have an authenticity program. There's a mention of it on our website that says, here are all the people that are allowed to sell our actual brand. So if you're buying it from somebody else, it's probably not real. We also have put together a guide for customs that talks about here's how you can identify that this dress is not a real Hervé Leger, for example. And then we also have been lucky enough to have somebody on the internet, I keep meaning to reach out to her, who is a huge fan of Hervé Leger dresses and has created her own website that tells you how to identify a knockoff, and also talks about the benefits of getting a real one over a fake one. So if you can find one of those, that's good too.
We also have one last comment.
Just real quickly, RFID now, look for it in the next coming generation of things where there will be an implanted chip in everything you wear that starts at the factory and goes all the way for the life of the garment into a landfill. And the problem is, legally, is this big brother watching you? So that's where that all is, but that's the next generation of what's coming because of counterfeit.
And lastly, I'd like to, Erica, if you could provide some of your thoughts and suggestions on licensing. Licensing is a very important part of the transactional part of what the in-house attorneys do, what the private firm attorneys do. So if you could, give us an overview of exactly what a licensing deal looks like, some of the important negotiation terms, and I was also interested to hear, in your experience, what are some of the kind of do's and don'ts when you're dealing with attorneys on the other side that you respect and things that you wish that you could avoid?
Okay, so licensing is critical in our industry. You can't be great at every area of the fashion industry, and if you really want to expand your brand, licensing is key. So our focus is on apparel primarily, and we license lots of our other products that bear our trademarks. So the biggest thing that I've seen is trying to figure out that balance between protecting your brand integrity and being fair to a licensee who you're hoping is going to be a long-term partner and making the license profitable for both parties. So it's a fine line. You obviously have much more of an invested interest in making sure that your brand is represented in the appropriate way, whereas the licensee just might want to maximize their profits. And so price point wise, they might be looking to sell some goods at a much lower price point than is sort of brand appropriate for what you would normally do. And so it's a huge negotiation process of what are the price points going to be, how much are you allowed to discount, who can you sell to. So the entire process is really about that issue in terms of where the real battles are and where I've seen problems arise later on when you're not respecting that balance. So a couple of ways to sort of deal with that are to set realistic minimums. So most licensing agreements will have minimum net sales provisions in them. You must sell X amount, and even if you don't, you're going to pay us on X amount. Well, if you are going to be very restrictive in the approval process and say, well, but you can't sell to this huge list of customers that you wanted to sell to, and by the way, you can't sell at a price point that you're telling me for this product that you're the expert in, we're not, is you're saying I need to go lower, I want you to go higher because that's better for my brand, but you're telling me you can't sell that. That's a problem. Things of that nature that you really have to look at your minimums and say, am I being fair to this person? Are these realistic? Can they meet them given what I know I'm going to want to do from a brand protection perspective? And I've seen a lot of issues come up with that because it's a hard balance. You're not the expert, they are, but you don't want to dilute your brand. It's a difficult balance to meet. I talked a little bit already about the potential discount and closeout pricing. That's obviously an issue. If they're not meeting their minimums, they have a bunch of leftover stock and they want to be able to get rid of it in order to try to meet those minimums. And one way to deal with all of these issues is to make sure you put in provisions that allow for approvals at various steps along the way. So before the licensee goes all in on their expenditure for a product and produces a ton of them, and now you're saying, actually, I don't love this product, you've dealt with that already. And you've made sure that you're okay from a quality control perspective, from a image perspective, from what's going on in your trends for your line, those types of things. You do it up front on the sample part of the approval process, and you can just say, know, or even earlier on, just send me an image of what you're thinking before you really spend any money, and let's knock out the ones that I know are not going to be brand appropriate before you go out of pocket, because that's where the real conflict comes in. I think that's it. Was there another part of the
That's
question?
great. That was great. We are going to wrap up. I'd like to see if any of the panelists had any closing comments.
Well, on that licensing thing, there's a new issue coming up also, mergers and acquisitions. What happens if somebody buys the brand? Macy's bought Tommy Hilfiger. Macy's, J.C. bought Liz Claiborne. So now you have Liz Claiborne coats that are an upscale brand, and they sued the hell out of that company, and he went out of business, but he went out of business a multi-millionaire because the sell of that brand to J.C. denigrated the value of his line. So that's coming up now. We have all these companies, mergers and acquisitions, and acquiring other companies, and that divorce in a license agreement is harder than the marriage, as in divorce and marriage, right?